right. Good morning, everyone, and thanks for sticking around hear from me on recruiting and retaining workers in 2022, as well as some key labor and employment law updates that I'll be tackling at the second half of the next hour or so. The topic of recruiting and retaining workers, unique to construction. It is. I'm tackling this strictly as a labor and employment attorney, as a business owner myself, and because it goes beyond just construction. It's impacting the labor shortage, and the labor market is impacting all industries. But I will try and inject as much experience and some helpful insights and tidbits to try and give you some leg up going forward. And if nothing else, some food for thought as you go forward in 2022. It will continue to be a challenge. And one of the articles that I read recently on this was from CNBC. They published a pretty good article a couple weeks ago. High turnover expected to continue in 2022. It's not a shock to any of us. The war for talent will continue. And I thought it was interesting that the point in the article, and a point that I've been making over the last year, is we may need to modify our onboarding, our hiring requirements, our training. We may, beggars can't be choosers. And it's not, I'm not saying you have to completely terminate your standards and compromise your standards or terminate how you go about hiring and selecting people and interviewing people. But I think we have to maybe modify, pause, think about changing how we go about onboarding and hiring, because, again, beggars can't be choosers. And the war for talent is going to be even more intense going forward. Now, there's not enough workers to go around. That's the point of the article. Labor market recorded 10.6 million new job openings in November. This is what stood out to me in the article. Another big gold nugget was roughly 65 unemployed workers for every 100 job openings. So it's just not enough. There's just not enough bodies. There's just not enough workers to go around. Construction industry, demand high, and the training of those workers in the construction industry is sort of taking a back seat, which is a little scary. Another source of information that I'll lean to is, of course, the U.S. Department Bureau of Labor Statistics. Some good information from BLS. And the BLS numbers, construction industry, specific to the construction industry, based on the December jobs report, added 22,000 net jobs in December 2021. Overall, the industry has recovered slightly more than 1 million of the jobs lost during the early pandemic stages, which comes to about 92.1% of jobs. So the construction industry seems to be holding its own in comparison to other industries for the race for talent. The construction unemployment rate rose to 5% in December. And then unemployment across all industries fell from 4.2% in November to 3.9% last month. Labor market, and this is a good quote from the ABC, Associated Builders and Contractors National Office in Washington, D.C.'s chief economist. The labor market remains extremely tight going into 2022. Contractors will be competing fiercely for talent. Competition will become even more intense as dollars from the infrastructure package flows into the economy. Contractors should expect another year of rapid wage increases in 2022. Those rising costs, along with others, must be included in bids and margins are to be sustained. And again, the point that I'm going to continue to go back on is, we need the dues. Beggars can't be choosers. It reminds me of the Delta House. You know the Delta House, Lynn? Lynn's over to my left. She's off camera. Delta House? Beggars can't be choosers. We need the dues. We need bodies. We need personnel. So with that in mind, we don't want to go out there and get a bunch of flounders. We need good quality workers, trained workers. And some of the things, so it's that race for talent. It's that competition for talent. Topics that I'm going to want to discuss and go through it, some a little slower than others. Remote work options. And I understand this is the construction industry, but you have back office, you have front office, you have accounting, you have clerks, you have payroll, you have estimators, you have folks that are working in offices. So that's talent. It's not just the trades. It's not just the trades that we have to be concerned about. So remote work, signing and retention bonuses, other types of bonuses, perfect attendance, gifts, prize drawings, deferred compensation, the golden handcuffs, if you will. Flexible scheduling, non-compete agreements, and how that might enter into this discussion. Temporary relaxation of background checks. As I said earlier, the modification of your standards or your procedures. Not to, I don't expect anyone to compromise their values and their principles and their what they expect, their expectations. But I think we have to be a little mindful of the race for talent, and it's just that the dilution of that talent pool going forward. Revisions to perhaps drug and alcohol policies and other employee benefit programs to keep an eye on for the race for talent. So talking about remote work, this is again not in the field, the back office. You can promote, you can create, you can take on temporary policies and give a temporary green light for people to work remotely. And what I'm seeing and just dealing with a lot of different clients and a lot of different industries, employers being more open to allowing individuals to work remotely. Now, there's pros and cons in doing that. I don't want to just state the obvious, but maybe not so obvious to some of you is the income tax and unemployment issues being triggered. Having individuals permanently move or go and work remote over a long period of time in a calendar year can trigger some tax consequences that some employers are just oblivious to until it's too late. So you need to be mindful. The rule that I'm not giving tax advice. I'm not an accountant. I have absolutely no tax or accounting background whatsoever. But what I'm hearing from the CFOs to the CPAs and the accountants and the tax attorneys that I know, that if you're allowing somebody to work remotely out of your state, out of the area, out of the state where they are accustomed to be working, and if it's more than 6 months, you're creating potential liabilities and problems from a tax standpoint. I've heard some even be more conservative than that, just from an ultra-conservative viewpoint, and they don't want people going remote more than 90 days. So if you establish remote work, you can create rules that you can work out of your home, you can work remotely for a period of time, but you need to stay within the confines of their state, whether it's Illinois, Indiana, California, Florida, Texas. wherever they are accustomed to be working, just stay within your state. If you're going to go somewhere else, have it be temporary. It may be no more than 30 days or 60 days or 90 days. Give thought to the remote work option to attract and maybe even have to be implementing something that you might not want to implement for a variety of reasons in order to retain or attract key talent. The signing, retention, and referral and perfect attendance bonuses. So, this is sort of the warning in the presentation. Wage and hour pitfalls are real. They're very real. I think folks in the construction industry, particularly with multi-employer bargaining arrangements, collective bargaining, the area-wide collective bargaining agreement, construction industry employers have a tendency to just rely on that collective bargaining agreement and think, hey, as long as I'm not violating the collective bargaining agreement, I got nothing to worry about. I basically can do whatever I want. It doesn't work that way. Anyone employing an employee can be sued for wage and hour problems and issues. Heck, I've seen collective bargaining agreements that violate wage and hour law. I mean, it's been a while since I've seen something like that, but they do exist. And so don't be so reliant on your collective bargaining agreement, especially when you start to implement signing bonuses, retention bonuses, referral bonuses, and perfect attendance bonuses. First and foremost, if you are part of a collective bargaining agreement in the construction industry, those are subjected. That's a subject of mandatory bargaining. There is a bargaining obligation in implementing. Depending on your collective bargaining agreement, there's likely a mandatory obligation of bargaining, but that's a secondary issue. I've never had a union balk at implementing benefits and perks that go beyond the collective bargaining agreement. So I think it's a pretty soft issue to implement with any business representative or agent. But turning back to just wage and hour implications and pitfalls, when we talk about bonuses, signing bonuses, retention bonuses, perfect attendance bonuses, and the like, you've got to pay attention to how those bonuses could trigger overtime calculations or wage payment obligations. If a bonus is a gift, then it does not need to be included in the regular rate of pay. There's no overtime calculation. It doesn't skew the overtime calculation. But if we're talking about retention bonusing and certain bonuses tied to the sweat of a worker or effort of a worker, a condition that the worker needs to meet in order to achieve that bonus, then we start getting into an effect on overtime, if it's a dollar amount. If the bonus is based on a strict percentage of pay, then you're not triggering this overtime problem. But often, most often, this bonus, it's not discretionary. It's not a gift. There's a condition. There's limits to it, and you have to basically earn it. And if you're earning it and it's not tied to a certain fixed percentage of compensation, it's a dollar amount of bonus that's coming to the worker, that will skew the overtime calculus. It skews it. So as soon as a condition is placed on the payout, overtime is skewed, and that regular rate is impacted. The bonus paid will become part of the regular rate of wages for overtime calculation purposes if and when overtime is worked during a period that covers the bonus payment. It can get confusing, and it can. I think that the backdrop here is anytime you're implementing a bonus and it's tied to some output by the worker, you've got to be careful. It's an issue you have to address and have a conversation internally. Payroll, HR, accounting, finance, you've got to have a conversation and identify the issue, identify the risks. Additionally, a condition on the payout tied to employment at the time of payment or tied to a certain length of service can also require a pro rata sum to be paid out. So going beyond, let's say, going into a retention. A lot of companies are creating retention bonuses. And this is a good example. Well, or a sign-on bonus, and there might be some sort of callback provision or something tied to you have to be employed for a certain length of time, and in order to get the payout, you've got to be employed on a certain date. Again, if there's conditions tied to the payout and that employee honors those conditions, meets those conditions, even if it's if they're there for part-time. For example, retention bonus. If you're here for the next 6 months, you'll get $6,000. All right. That person leaves or is terminated 3 months into this 6-month period of time tied to the $6,000 bonus. In some jurisdictions, in a few jurisdictions, Illinois, I know a lot of attendees here today are Illinois-based. Illinois, California is another jurisdiction that has this pitfall that unless the person voluntarily leaves on their own, not attributable to the employer, you would have to pay out some pro rata form of that $6,000 tied to the 6 months of employment. And so another potential pitfall with retention bonuses or a sign-on bonus tied to a specific term of employment where you've got to be employed at a certain time to get the payment, be mindful that in some jurisdictions, for example, Illinois and California, will require some pro rata. So if the person's here for 3 months in Illinois, there's an argument that they would be entitled to $3,000 of the $6,000, regardless of the language used to implement this program in the policy or the plan or the memo or the communication. So be mindful. Of course, you can, in some jurisdictions, you can have forfeiture. Forfeiture is okay if they voluntarily resign, not attributable to the employer, or they're terminated for good, valid cause or reason. And clawback provision, that doesn't change. A clawback and forfeiture are basically the same thing. So I've seen a lot of this recently. You come on board and I'll pay you a $5,000 bonus. All right, that's all. You can attract a lot of people. $5,000 is not chump change. That's significant money. You bring them on board, but then you say, if you leave in the next year of employment, you forfeit. We claw back that $5,000. That could be a problem in some jurisdictions. And again, I go back to Illinois, I go back to California. If they voluntarily leave or you terminate them for good cause, likely not an issue, not a problem in some of these problematic jurisdictions. But if you don't terminate them for good cause, you lay them off, or there's really no there's no compelling reason for the termination or separation, or they voluntarily leave because of harassment or something that's attributable to the employer, some sort of constructive discharge, that forfeiture, that clawback, likely is not enforceable under some of these problematic jurisdictions. So again, the point here, I hope you're paying attention to the fact that there are pitfalls in your good deed, your benevolence, your efforts to try and attract personnel. On the referral bonuses, again, it probably would be deemed a gift. If you have employees and you're encouraging your own employees to refer talent to the company for hiring purposes, it's probably a gift if it's voluntary. The recruiting is not part of the employee's regular job duties. And that's often the case, right? A referral bonus, and typically a referral bonus is paid out to people that's not their job to recruit. Their job is to, be in the trades. Their job is, accounting. And typically referral bonuses are not in place for your recruiter or for your HR department, for example. They're typically excluded from referral bonuses. Sorry, HR. Of course, the time needs to be minimal activity, minimal time. So maybe it's over a beer, maybe it's over a coffee, maybe it's at a barbecue. It's an informal way and a limited amount of time that worker is spending trying to recruit people to come to work for you. So typically, a referral bonus is a pure gift. And it's not going to be looked the same as a retention bonus or a signing bonus or a perfect attendance bonus for that matter. Now, if you then tie that bonus to longevity, requiring the referral or the referring employee to be employed in the future to get paid, then that can trigger the overtime calculus for those that are non-exempt, those hourly employees. So there's always that overtime calculus that comes into play when we're dealing with conditions placed on a bonus. That overtime calculus can change. Prize drawings. I've been practicing for 24 years. I've never really discussed prize drawings and like lottos and stuff. Desperate times call for desperate measures, I suppose. And so I'm starting to see more and more businesses come up with a lottery, a prize drawing. If you're employed by, if we hire you by, before the constraint, let's say by March 1st, if you become employed with our company by March 1st, 2022, and you stay employed till December 1st, 2022, we will have a drawing, okay? We're going to have a drawing, and we'll have a drawing on December 15th, 2022. And we're going to draw, you'll be eligible. Your name will be put into the lottery, into the drawing, and we pick your name, and you'll get a $10,000 prize. Sounds pretty good. I don't know. I've got a number of businesses and organizations in the construction industry, outside the construction industry, to try and again to attract and recruit people, and they're creating these prize drawings. And they're kind of cool. I think they're pretty cool. Who doesn't want the chance of making $10,000? I had one business come up with a lotto for $50,000, $50,000. Not construction industry, not construction. They were a food processor. They were really, really desperate for talent. $50,000. I mean, that's. And some of the people that had their name, it was like as much as they made in a year, if not more. It was serious money. So it got a lot of people, got a lot of attraction, got more applicants to take interest in working for this organization because they, announced it and made it that it was a kind of a race to get hired. Because if you were hired by a certain date, and as long as you stayed employed for 6 to 8 months after their real busy season, then you have your name in this lotto. Sounds great. You are triggering all sorts of potential problems under gambling laws, believe it or not. So when you go through and you implement some sort of lottery of sorts, you need to keep in mind that there's gambling laws. It's a state-by-state issue, but most states have anti-gambling laws. So if you're going to implement something like this, there's certain legal disclaimers that you need to have in place. You also need to be very careful of defining who's eligible and how it all works. And if there's no strings attached, and it's really just a matter of somebody, as long as you were employed on X date, and as long as you stayed employed to X date, to get your name in the lotto, to get your name in the drawing, it's typically going to be deemed a pure gift, and you're not going to be triggering all these problems outside of potential gambling issues. So you've got to have certain disclaimers. We have I don't know where's that coming from. The phone's ringing. I apologize for that. But we actually have templates and sample prize drawings that we've created over the last 12 months to help our clients on this issue. So moving forward to deferred compensation, this is another way to address the golden handcuffs and trying to put golden handcuffs on key individuals. It doesn't have to be executives, but key people within an organization. There's nothing illegal or invalid about putting some sort of retention bonus, triggering some sort of continued employment, and in some future date, 2 years from now, 3 years from now, 4 years from now, it's pretty typical to have like a 5-year wait period where there is compensation that is accruing. And that compensation is then tied to longevity. And that would likely will trigger some sort of deferred compensation, which just means that you are going to have to comply and identify the deferred compensation rules under the tax code. So if you're looking to tie key individuals within your organization, they could be at any level, they can be anyone within an organization. The arrangement needs to be in writing, and that written plan document needs some underlying plan document. It could be individualized. You can have these plan documents and a deferred compensation plan unique to certain individuals or group of individuals. There's a payment date, a form of payment, and the timing of the payment needs to be cemented in that document, and then it cannot be changed once it's cemented in that document. You also need to consider longevity bonuses, whatever you're doing informally, with an eye on deferred compensation. I suppose another way to look at what I just said about deferred compensation is to create a deferred compensation plan. They're not that complicated. You just got to get the advice of proper counsel. But a mistake would be to create a deferred comp system de facto and not realize, oh, shoot, we're triggering a deferred compensation issue under the tax code, under the Internal Revenue Code. That's a problem. So be sensitive to longevity bonuses and tying people's hands without creating a deferred comp program. That's a problem. That's a tax problem, and you don't want to be facing that down the road. Flexible schedules. This is, again, more, I understand that there are participants today that, your hands are tied on schedules because it's tied to a collective bargaining agreement. It is what it is. But for those of you that are not tied to a CBA, or you have some flexibility, I think that this is starting to become more in vogue, and more popular, is trying to come up with some flexibility. And you come up with a flexibility schedule, that is, it's fine, and it's good business to make sure that it's temporary. When you're implementing things in light of the current labor market crisis, if you will, you need to be cognizant and aware that all of this is temporary, right? And making sure that any communication, anything that you're implementing, has appropriate disclaimers and language in the communications, that the company, the organization reserves the right to modify what we're implementing today. We can modify it tomorrow if we need to, or if we want to. Nothing is set in stone in this day and age. You got to be careful. Make sure that business needs to get done. It's getting done, but there's really nothing preventing an employer from coming up with different schedules and different arrangements for the as long as it meets the business needs, obviously. But be mindful of local and state mandates and different. Maybe your hands are tied depending on where you are, based on local or state scheduling work restrictions. For example, the Chicago Fair Work Week ordinance comes to mind. Restrictive covenant agreements. Now, I bring this up for a couple reasons. It's non-compete agreements, non-solicitation clauses, non-disclosure agreements. They're relevant. They're relevant, and you know what? They're effective if they're done right. They're very effective. To attract somebody within your organization, putting them under a non-compete, I don't know if now's the time to be doing that. To each their own. You've got to protect what you think you need to protect. But also be mindful that there is now a growing trend that is targeting the construction industry. Illinois being a prime example of creating legislation that strictly bans non-competes. So, for example, Illinois bans non-compete agreements, the traditional non-compete agreement, for construction tradesmen. So if you have workers in the construction trades, those field workers, those construction site workers, they are not allowed to enter into a non-compete on or after January 1st, 2022. That's an Illinois thing, and it's sort of the new trend that's popping up in like-minded states, for lack of a better phrase. However, management personnel, sales, engineering, owners of these construction businesses would not be covered by that ban, that Illinois ban. The Biden administration is also currently examining this issue, and what I'm hearing is tying federal funding to ensure that the recipient of the federal funding doesn't have certain non-competes in place with certain workers. So I anticipate that will come into more focus in the coming in the coming months, if not years. They sort of have their hands full in Washington these days. But the point here is, maybe look at, if you're having a hard time attracting talent, is it because of some sort of restricted covenant? Whether it's office or field, evaluate that. A non-disclosure agreement that doesn't, there's really no restrictions other than don't use my trade secrets and confidential information against me. Don't underbid me if you leave my employment. or you're terminated from my employment. Don't underbid me. That those agreements have tremendous value and can be quite effective, and doesn't have the sting that the more traditional restrictive covenant, i.e. the non-compete, would have. Or even to reevaluate your restrictions relate to solicitation of customers. There's no Illinois ban on solicitation of a customer or an account. And so that's another measure to take to try and take the sting away from somebody coming on board, and maybe they don't want to come on board because of some restrictive covenant that's just too restrictive. So give thought to that. Also, I look at non-competes as a way to try and keep people with you, right? It's tie their hands a little bit, if it's effective. So it kind of plays both sides of the fence with the non-compete issue and the restricted covenants. Background checks, criminal credit histories, education, references, past employer references, social media. Do you suspend it? Do you eliminate it? Do you modify? Well, do you have a choice, right? And it's what I said, this, and that CNBC article, echoing that same thought, is do we modify our onboarding interview process, the way we filter out applicants, job applicants? Do we modify it to be a little bit, less restrictive, less, time consuming? Well, the first question that I would have for you is, do you have a choice? I mean, there's certain mandates in certain occupations or for certain customers. You might have you're doing work for a certain customer, and they require certain minimum background checks because you have got construction workers going on site, and they've got to go through a more intense screening. Okay, it is what it is. So you might not have a choice, whether it's legal mandates or something that a customer is demanding. But generally speaking, nothing prevents you from temporarily, again, the key term here is temporarily modifying or suspending your standards, your requirements, your processes. But be careful, word of the wise, you still need to know who you're hiring. So what I recommend is, I think that for a lot of reasons, just from a risk standpoint, from a general liability standpoint, you need to know who you're hiring. Running those backgrounds, getting those criminal conviction histories, looking at the references, looking where they worked, you need that information. Something about, somebody said, like, knowledge is power, or information is power. Some phrase like that. I don't know who it was. I think it was Benjamin Franklin or Thomas Jefferson, one of those guys. You need that information to make informed decisions and figure out who's working for you. Because even if you're going to hire that flounder that you would not have hired, you would not have accepted 3 years ago, you need to know what their background is so that you can properly manage and take action, proactive action, smart action and management to make sure you've got your finger on the pulse, if you will. So don't just completely eliminate your onboarding screening, your interviews, your background checks. You just might, have to hire people that you would not have otherwise hired a few years ago because of the market. And then now you know what the risks are, you know their background, you're taking in a calculated risk, and you can better then manage the risk. With this topic of interviewing and onboarding, drug tests and screening, alcohol, cannabis, illegal drugs, again, do you have a choice? You might be under mandates from a customer or legal mandates where you do not have a choice. Remember, in Illinois, for example, there's if you're doing public work, you need to have some sort of drug testing as part of your collective bargaining agreement, or if it's not part of a collective bargaining agreement, or you're not part of a collective bargaining agreement, you got to have certain drug testing protocols in place. A lot of states, for public work purposes, has this mandate, and you need to be cognizant of those mandates for certain public for public jobs, for public work. So it might not be something you can eliminate or suspend, depending on the nature of the business. But where and when you can, you might want to, again, modify. Be careful of your individuals that are working in the field and be mindful of the safety-sensitive positions. But generally speaking, there's nothing preventing an employer from modifying a drug policy. Absent some sort of contractual obligation under a collective bargaining agreement, but generally employers can modify that's going to fit their business needs at the time. So real quick, because I want to segue into the labor and employment development, and I'll just kind of go through these slides quickly, as voluntary benefits, programs being offered to try and attract people from, critical insurance coverage, accident coverage, ID theft. I've got some clients that actually are starting to offer pet insurance as a perk. I mean, they're trying to come up with all sorts of different ways to attract and retain talent, including more popular benefit would be some sort of long-term disability benefit. Just be mindful when you implement those policies and those benefits. There could be ERISA and tax implications. So give thought to it. The other one that's getting more popular is the unlimited PTO. It looks good. It's kind of it's pretty attractive, right? Be careful. You got to be careful of the language and the communication, because some jurisdictions, California and Illinois. I always go back to those. Some jurisdictions, California and Illinois, are always top of mind. We'll look at to maybe force a payout of unlimited PTO at termination, and base it on what that employee would have likely used but didn't use if you're not tracking it. So unlimited PTO can be cool and it can be a real good benefit, but understand that you've got to have some parameters around it and give some careful thought to it for implementation purposes or prior to implementation. Other some considerations is watch for potential equal pay issues. We're looking at bringing people in, and we're focused, we're hyper focused on the new people coming in and paying them and throwing money their way. We're hyper focused on that. That can create equal pay issues. That could create unequal treatment, disparate treatment, discrimination. You didn't intend to discriminate, but your practice is just, de facto, it's discriminating, or it's creating equal pay disparities amongst people doing substantially the same or similar work. Be mindful of that. Some other ideas, vacation bonuses. Again, go above and beyond for those that are under a collective bargaining agreement. Go above and beyond the CBA. Again, I've never had a union business agent that complained or took an employer on in arbitration or grievance because they went above and beyond the CBA. I've yet to experience that. I've heard some weird stories over my years, but I've never personally experienced that. The vacation bonuses, giving an employee an amount to spend on vacation. You got your vacation, but we're going to give you like a vacation stipend, and we're going to do that in 2022. We might not do that in 2023. We might not do that in 2024, but we're going to do it in 2022. Clothing allowance, especially now, jackets and something where where there's an additional perk. Child assistance, child care assistance is big. Tuition assistance is really big, and and even setting off loans, student loans or other loans, recreational memberships, online subscriptions, union obligations. Again, I've already explained, but if you're under a CBA, giving away more money should not be a problem, but we're triggering subjects of mandatory bargaining. And so I always kind of let's give the business agent an FYI. If you've got any problems with what we're doing or implementing, let me know. And you got to be careful for those that have the CBAs, you got to be careful on benefits, those fringe benefits being triggered. This is sort of a gold nugget as I conclude this portion of the presentation. I turn to key labor and employment. When you give away money, you got to look at the fringe benefit contributions under that CBA. Is the fringe benefit being contributed by the working hour, an hour actually worked, or is the fringe benefit contribution, whatever the fringe benefit may be, or the contributions that you have to make into the funds, is it tied to just money or a percentage of total monies? So be careful. That's going to be a CBA by CBA analysis. And some employers that have multiple collective bargaining agreements, they're not all created equal with respect to tying the monies paid or received to the fringe benefits and vice versa. So be on the lookout for that. And then refusal of work. Yeah, so I kind of want it, is this still happening? Are people refusing to come to work? There's a lot here. You can read it for yourself if you can read it. I think the slides are being made available too. Right, Lynn? So everybody's having. So take a look at this. I think it's important that we demonstrate in writing that there's no obstacle to come to work, to return to work. It's safe. We're doing what we need to be doing with respect to COVID, and there are opportunities aplenty within the organization, so you don't have people playing that game. All right, so moving on. But before I move on, there's a question here in regards to deferred compensation. Wouldn't it just be easier to structure an agreement with scheduled pay increases at set times during employment based on whatever metrics you desire, time, performance? Yeah, I like that. I like easy. Sometimes, employers want to make deferred compensation. They implement deferred comp with really, that golden handcuffs that we're going to defer this compensation to future years, and so you're not going to get payments along the way. You've got to be here, and you're going to get this money down the road. 3 years, 4 years, 5 years down the road. So there's pros and cons and everything, but that's to try and avoid deferred comp because you don't want to trigger those IRS issues. Absolutely, there's ways to go about it. It means you're probably going to be paying that worker out more regularly in that year in which the metrics are met. Oh, good question. Okay, so updated laws. The majority of those participating today are in Illinois. And I'm if you're not in Illinois, that's fine. I'm just kind of giving you a rundown of what's happening in states that, good, bad, or otherwise, I don't know how else to phrase it, are more programmed to create more laws and more regulations. Illinois is one of those states. Indiana is not one of those states. Wisconsin is the last couple of years has not been one of those states. Missouri and Kentucky, and I'm just looking at the states surrounding Illinois, right? Iowa. been pretty, kind of not very active in workplace regulation. Illinois has been very active in workplace regulation. So, real quick rundown of some Illinois laws here. The Human Rights Act. Every employer with any employee in Illinois is subject to the Illinois Human Rights Act. You cannot discriminate under the Human Rights Act on terms and conditions related to employment based on protected classifications, protected bases, national origin, race, age, religion. So some construction contractors, they don't know what they don't know, and I think it's important to assert and state here that Illinois has specific civil rights laws that cover all employers, even an employer with just 1 or 2 or 3 employees, those small contractors. The Illinois Human Rights Act was amended in 2021, effective March 23rd, 2021, that prohibits employers from using a criminal conviction against an employee or job applicant. You heard me right. Illinois has a law that prohibits employers from using a criminal conviction against an employee or job applicant. Well, there's exceptions. There's 3 exceptions. If the law precludes you, a state or federal law precludes you from employing this person in a specific job with a specific conviction. U.S. Department of Transportation, certain regulations, certain serious moving violations, traffic violations, where you've got a certain conviction, I can't put you behind the wheel of the truck. That's a good example, right? There's 2 other exceptions, and those exceptions are if the position would create there's a substantial relationship between the position and the conviction, or there's an unreasonable risk to person or property, and those are legal terms of art. And there's an interactive approach and process, and it's kind of complicated. And I don't want to spend a lot of time on it, but I want you to understand that it exists. And this is a trend. We're starting to see this come up in New York, for example. We're starting to see this in certain, more active states. And this is impacting construction. The construction industry is not like exempt from this rule of prohibiting this trend of prohibiting employers or limiting an employer's use of a criminal conviction. So just be mindful of this. And if you are looking at criminal convictions in the hiring process or as part of your best practices, keep an eye on this, on local and state law. And if you're operating in Illinois, you need to have this, law. This law needs to be familiar to you. We talked about the non-compete, the Freedom to Work Act. It changes the impacting non-competes and non-solicits. Something I didn't mention is in order to have a valid non-compete in Illinois as of January 1st, 2022, the person under the non-compete has to make more than $75,000 a year on an annual basis. And for a non-solicitation to be enforceable, that individual would have to be earning more than $45,000 annualized. So where and when you can implement a non-compete or non-solicitation, you need to be mindful of these salary thresholds that goes with the Freedom to Work Act in Illinois. And again, this trend of trying to regulate non-competes and non-solicitations, it's not just unique to Illinois. Wages and unpaid wages. Illinois changed the law in July 2021 to make a interest penalty from 2% per month to 5% per month. So if you're not paying wages, if you're not paying bonuses the way you should, or the full bonus, if you're not paying the commission if you're not paying out the vacation as promised, you would then be on the hook for a 5% per month, not per year, a 5% per month interest rate on whatever back wages you owe. Under the statute that I'm referring to with respect to unpaid wages, Illinois has a 10-year statute of limitations. So, if you don't pay properly by accident, it could be completely by accident, a mistake, $1,000, that's $600 a year accumulating for at least 10 years. It goes on until the actual payment is made. So it's a big liability. I can tell you, and this is sort of jumping ahead a little bit to what's coming in Illinois, is there is I'm going to jump ahead a little bit here. There is banter about changing wage and hour law in Illinois again with the construction industry in mind, because that's where the proponents of what I'm about to say, that's where they're seeing problems, is if workers are not paid wages, and they're saying that they're not being paid, construction workers aren't being paid properly, the business, the contractor goes belly up. They're out of business. They do the job, they do the work, the contractor gets paid, and then all of a sudden you don't see the contractor anymore. Now I'm not here saying that that's truth. I'm just saying that that's what some proponents of continuing to change wage and hour law, that's what they're relying on, or some horror stories about workers not getting paid on construction jobs. There is still an effort in Illinois to try to throw that liability on the upper tier contractor. Now, right now, I don't see that gaining the traction that it needs to as of today. It could change tomorrow. But those efforts have been underway for the last couple years. Be mindful of that. If I'm an upper tier contractor and I'm relying on a sub, I'm hiring a sub, you've got to have appropriate assurances. You've got to have appropriate contractual rights and obligations and protections in place. You've got to know. More importantly, I mean, what's a contract's only as good as the person who's signing it, right? You got to know who you're getting into bed with now more than ever, because this is not just an Illinois issue. This is being bantered about at the U.S. Department of Labor, where wage and hour enforcement, what can we do to enforce wage and hour laws to upper tier contractors that are good for it, that have the means to pay workers that are not paid on jobs? And you think about it, who they're going to go after? They're going to keep going to the upper tier and even the general contractor when it's all said and done. So, now is the time. You've got to know who you're getting into bed with. You got to have the assurances. You got to make sure the bonding is in place, and everything that's a Matt Horn issue. That's a Dennis Cotter and Matt Horn exercise to make sure what you got to have in place from a wage and hour and from a contractual standpoint. But be mindful that this effort is not just underway in Illinois to make sure wage obligations are honored. If the actual employer goes belly up, they're looking to tie it to somebody or something to pay these workers. ultimately. Those workers are going to get paid. There's also efforts in the same wavelength of expanding the term joint employment. And this is not only on certain states, i.e. Illinois, but also on the federal level. So I know I'm jumping ahead a little bit, but I want to, just from a time standpoint and as we get through the material, I want to make sure that is a big gold nugget item for today's discussion. The joint employment or upper tier contractor liabilities with specifically tied to wage an hour. I skipped prevailing wage. Maybe I did that on purpose. But real quick on prevailing wage, I'm not going to go back, but on the prevailing wage, Illinois is starting to implement a online system where certified transcript of payroll information would be available online for anyone to view. So you wouldn't have to, individuals or third parties would not have to FOIA the Illinois Department of Labor. It would automatically be available online. I have not seen them successfully implement that, but we'll see how that unfolds in the coming weeks and months here in Illinois. So moving forward, now on the federal, more big picture, the Biden administration and what they're looking to do. The Build Back Better legislation looks like it's not going to get through in its current form. And now they're looking to kind of piecemeal it and see how they can maybe piecemeal it over the next several months. So we'll see where that goes. There's a lot of labor issues that are in the Build Back Better legislation. A lot of and really important is the funding of these entities in front of you. The EOC, the U.S. Department of Labor, OSHA, a lot of billions and billions of funding. So as I sit here today, I think it's just a matter of time before we start seeing legislation that's more surgical and giving the resources and the and even codifying some changes that some of these U.S. these agencies, U.S. Labor Employment Enforcement agencies want to see. But one of the things that the Biden administration was able to get done real quick, fast, I mean, it was immediate, is the changing of the guards with these agencies. And I calls it as I sees them. The Trump administration had more pro-business, pro-employers running these agencies. It shouldn't be shocking to anyone. The Biden administration has more pro-employee, pro-union, individuals running the agencies. It is what it is, good, bad, or indifferent. And the key agency that I think goes beyond union. It's not. Everyone thinks that the NLRB is just this, agency that oversees unions. No, they oversee all workplaces, and specifically construction. The NLRB majority they're pro-union. Again, good, bad, or otherwise. You might think that's good. You might think that's bad. You might not have an opinion. What you need to understand is that there's a full board. There's a majority that's pro-union, and there are specific cases tied to construction that are on their radar. And I think that we're going to see in the next 12 months, in 2022, more decisions that are going to give the unions more freedom and flexibility on picketing and secondary boycotting and other, those traditional methods that the trades will use to try and shut down or delay a job in order to get their people on the job. And in my experience, this is not a union versus non-union issue. A lot of the disputes that I see on job sites is unions going after other unions. And boy, I mean, you want to talk about the solar energy industry. Every major trade union is going after the solar. Is it the carpenters' work? The IBEW would say it's the IBEW work. What about the laborers? There's a turf war going on brewing with a lot of this, this green energy movement. And it really is remarkable to see they're fighting each other on this work. So this is not just a union versus non-union. There's jurisdictional disputes, and we're going to see in 2022 the labor board being much more active in these disputes going forward. Understand that the new NLRB's general counsel is looking at ways to make consequences for unfair labor practices more economically harsh for employers, going beyond the traditional back wage, getting into consequential damages. The National Labor Relations Board's general counsel, which is the policy maker at the National Labor Relations Board, looking at ways to making union organizing easier, even requiring an employer to recognize and bargain with the union where the union simply shows a majority representation status through card signing. Some of these initiatives that's being bantered about at the NLRB also includes forcing employers to not only bargain in good faith, because you've got that obligation, but to actually force the employer to enter into an agreement that they might not want to enter into through facilitation through the Federal Mediation and Conciliation Service. How this might impact multi-employer bargaining is to be seen, but I don't see how this wouldn't apply to multi-employer bargaining, which is common and unique to the construction industry. But again, that's the NLRB's general counsel with these thoughts, with these ideas, these concepts of moving forward more aggressively to make the unions stronger and the union contract easier to secure on the terms that the union wants, not what the employers or the contractors or their bargaining association necessarily wants. So we'll see how that goes, and a lot of what the general counsel wants to do, it would be through case law, policy implementation, and legislation, and they might be able to get the legislation they need to get through in the coming months. So I don't know. I mean, can they convince 10 Republican senators to get through the filibuster? Which is, timing is everything. They didn't destroy the filibuster yesterday. So tomorrow's a new day, and we'll see how that all plays out. But I guess the bottom line is, if the general counsel at the NLRB gets what she wants, if she gets this much of what she wants, it's a whole new ball game. Good, bad, or otherwise. I can say whatever I want, Lynn, as long as I say good, bad, or otherwise at the end, right? What's on the horizon? Federal, I want to just pick some big ones here. Union contractors, project labor agreement. I mean, I can go through those lists. You can read it for yourself. But the one that sticks out to me with this audience is the PLA, the use of a project labor agreement, where project labor agreement is basically you've got to honor the underlying collective bargaining agreement. There's a lot that goes into that. They're not all created the same. They're different. The project labor agreement, with respect to the non-union contractor, the devil is in the details. Know what you're getting yourself into. It's one thing to sign and agree to a project labor agreement. I will conform to the union contract. It's another thing to actually sign and become signatory to that union contract. The devil is in the details. For union contractors, Don't think that a project labor agreement, hey, I'm union, I can enter into no problem, I can enter a project labor agreement. There's jurisdictional disputes. You might not be the right union. You might not be with the right union for the scope of work under that particular construction job. You've got to evaluate the project labor agreement and what unions are signatory and are part of the project labor agreement. Because if it's not tied to your contract, your specific contract, you've got to enter into a new contract or adhere to another contract that you might not be signatory to. So there's a lot of traps and pitfalls with PLAs. We've got to be sensitive to it, whether you're union or whether you're non-union. Real quick, EEOC strategic plan, pay equity. That is their number one priority, pay equity. We're seeing pay equity come up. It's in Illinois. We've got pay data. If you've got 100 or more than 100 employees in Illinois, you've got to start now submitting pay data to the state of Illinois. I don't know if you know that or not. The EEOC is looking at pay disparity and working in cooperation with the U.S. Department of Labor. The OFCCP and exchanging information and identifying employers where there could be pay disparities based on gender, and under pay equity, there's two genders, and ethnicity and race. So keep that in mind. And then what to do today and what's coming tomorrow. Real quick, I got 10 things, and then I'm done. Reassess hiring and onboarding rules and related processes. We've gone over that. Number 2, consider legal ramifications related to sign-on bonuses, retention and referral bonuses, other compensation-related perks, your benevolence. No good deed goes unpunished. You need to know what you're getting yourselves into from a wage and hour standpoint and what you're triggering. Also on the tax side, too. Number 3, review union-free preference statements, assess vulnerabilities to union organizing as a non-union contractor. As a union contractor, evaluate jurisdictional disputes. Are you with the right union for that project, or are there potential problems and issues that you need to dance around, particularly under a PLA? Number 5, conduct employment practices audits. Have an eye on wage and hour issues, rounding rules, deductions for breaks, start times, end times, expense reimbursement. Number 6, revise handbooks and policies. You remember the Obama era where we had these handbooks and social media and like these businesses being, in the media for not having the right social media policy? It's back. It's back. So you better have your handbook and your policy manual evaluated carefully with the right National Labor Relations Act disclaimers embedded into those specific policies that could draw the ire of the National Labor Relations Board, particularly this general counsel at the National Labor Relations Board. Number 7, audit, review, and address pay disparity issues, number 1 priority at the EEOC. Number 8, review and joint employer relationships and issues. Look at third-party contracts. Who are you tied to the hip with? Who are you getting in bed with? Number 9, review independent contractor relationships in the construction industry. You really need to be contracting with bona fide LLCs or corporations. Individual sole proprietors, there's nothing per se illegal, but it creates all kinds of potential problems. And 10, obtain the latest withdrawal liability estimates. Union contractors, when you are evaluating, even non-union contractor, if you're evaluating mergers and acquisitions, you're going through your due diligence, ignorance is not bliss. You need to ask those questions and get into details as to whether or not withdrawal liability and successor liability will be triggered. And that's a legal analysis, and you need labor counsel to effectively consider withdrawal liability issues, liabilities, and successor liabilities related to not only to the pension liability, but just to the contractual obligations in the CBA. And that's me. That's it. Let's see if there's questions. No more questions. Well, if you have questions, I'm here. And if you need anything, just reach out to Matt, Dennis, or I, or any Smith Amundsen attorney in our labor and employment group or construction group. we work side by side. We work in tandem together. I don't know if Matt mentioned that, but we are always. I'm on the phone with Matt weekly on a variety of different issues because they segues back and forth. So what's great about Smith Amundsen is the fact that we've got that construction, OSHA, and labor and employment practice groups, and they're some of, if not our biggest, largest practice groups in the firm. So thanks for your time and patience, and we'll see you next year.